New Jersey carjacking lawyer. If you are charged with carjacking in New Jersey, the stakes can be life-changing. A first-degree carjacking case can carry 10 to 30 years in state prison. You may have no opportunity for parole until at least 85% of the sentence is served. A conviction is not inevitable when the state cannot prove every element beyond a reasonable doubt. Carjacking is defined by N.J.S.A 2C 152 and is always charged as a first-degree crime. The law requires an unlawful taking or attempted taking of a motor vehicle plus an aggravating circumstance. If the aggravating circumstance is missing, the case may be charged as motor vehicle theft or unlawful taking instead. Under N.J.S.A 2C 152, carjacking can involve inflicting bodily injury or using force on an occupant or person in control of the vehicle. Carjacking can also involve threatening immediate bodily injury or placing someone in fear of immediate bodily injury. Another way the statute can be satisfied is committing or threatening to immediately commit a first or second-degree crime during the taking. The statute also covers operating the vehicle while the person in possession or occupancy remains in the vehicle at the time of the taking. To convict, prosecutors must prove you unlawfully took or attempted to take a motor vehicle. They must prove the taking was without the owner's consent. They must prove you intended to temporarily or permanently deprive the owner of the vehicle. They must prove that during the taking you used force, threatened force, committed another serious crime, or retained occupants in the vehicle. If any element cannot be proven, the charge should not result in a conviction. Carjacking differs from motor vehicle theft because theft does not involve force against a person. Carjacking also differs from robbery because robbery involves taking property from a person but does not specifically involve a vehicle. Carjacking requires both taking a vehicle and using force or threats against the owner or occupants. The sentencing exposure for carjacking includes 10 to 30 years and fines up to $200,000. New Jersey's No Early Release Act applies to carjacking and requires service of 85% before parole eligibility. A 10-year sentence means 8.5 years before parole consideration under N.J.S.A. After release, parole supervision lasts 5 years. New Jersey's 3 strikes provision can require life imprisonment without parole for a third conviction involving enumerated violent offenses including carjacking. Defense strategy often starts with challenging whether the state can prove the elements. Consent can defeat the unlawful taking element when the owner authorized use of the vehicle. Lack of force or threat can support reduction to motor vehicle theft rather than first-degree carjacking. Victim proximity can matter because carjacking generally requires the victim to be an occupant or in possession or control of the vehicle. Constitutional issues can also affect the case when evidence came from an illegal stop or search. Statements taken without proper Miranda warnings during custodial interrogation may be excluded. Improper identification procedures may be challenged under State v. Henderson. Mistaken identity defenses can rely on alibi evidence, surveillance footage, or cell phone records. Some cases involve claims of false accusations that can be tested through investigation of credibility and inconsistencies. Carjacking cases often include additional charges such as weapons offenses, kidnapping, robbery, and more. Prosecutors may also file charges like aggravated assault, terroristic threats, eluding police, or receiving stolen property. Each count can carry its own sentence, and courts may impose consecutive or concurrent terms. Under New Jersey bail reform, defendants charged with carjacking typically face detention without bail pending trial. Courts use the public safety assessment to evaluate risk rather than cash bail. If the prosecutor files a detention motion, a detention hearing is generally scheduled within 3 working days, subject to continuances. At that hearing, the prosecutor argues detention is necessary and the defense attorney argues for release with conditions. Judges consider the nature of the offense, the weight of evidence, and a defendant's history and characteristics. Winning release often requires evidence of stable housing, employment, and community ties. After arrest, the case typically follows a timeline from booking to initial appearance and detention hearing. Prosecutors usually present evidence to a grand jury within about 30 to 60 days of arrest. After indictment, defendants appear for arraignment in Superior Court to enter a plea. The defense and the state then move through discovery, motion practice, and negotiations. Trials may occur 12 to 18 months after indictment, and many cases take 12 to 24 months from arrest to resolution. Adam M. Lustberg, a New Jersey criminal defense attorney with Lustberg Law Offices, has defended clients facing carjacking and other first-degree charges throughout Bergen County and New Jersey. This law firm handles cases in Bergen County Superior Court, Hudson County Superior Court, and courts throughout the state. Retaining a lawyer early can help identify weaknesses in the state's evidence and pursue motions and negotiations. A lawyer can challenge a traffic stop, dispute whether force was used, and contest whether you had permission to use the car. A defense attorney can also raise illegal search issues, Miranda violations, and identification challenges when supported by the facts. Lustberg Law Offices, LLC is located at 1 University Plaza Drive No. 212, Hackensack, New Jersey, 07601, United States, and you can call 201-880-5311.